Hi, everyone. Thanks so much for joining us today. My name is Karen Vasquez. I'm with C3 Integrated Solutions. Thanks so much for taking some time. We really appreciate you being here. I'm joined by Bill Wootton and Jody Reed, who will be your speakers today. We're going to be talking about data defined, CUI and ITAR data from both a legal and practical perspective. Bill Wootton is the president of C3 Integrated Solutions, and Jody is an attorney with McMahon, Welch, and Learned with specialties in government contracts. Now, disappear from camera view and hand it over to Bill.
Thanks, Karen. Uh, with the entire industry, the defense industry moving towards getting ready for CMMC, we've all heard plenty of information about the basics of CMMC. What we want to do today is kind of dig a little deeper, go one layer further, and cover a topic that we hear about all the time from various clients, which is what is the difference between CUI data and ITAR data. There is some differences there, some really important differences, both from a legal perspective as well as from a technical standpoint. Jody is going to lead off today and give us the legal framework around the two different types of data. And then I'm going to come back in and talk through from a practical perspective, from an IT professional's perspective, what's most important, what should you be looking for, and how does this relate to our everyday world? So with that, I'm going to hand it over to Jody. I think we're going to cut off our videos for the moment, let you focus on the presentation itself, and then we'll come back on video for the answer session itself. So take it away, Jody.
Thanks, Bill and Karen. Welcome. The one thing I do want to point out as a disclaimer here is that I am not providing any legal advice. If you need legal advice, you do need to contact an attorney directly. Other than that, I welcome everyone to this presentation. We're going to talk a little bit about some basics. What is controlled unclassified information? The Controlled Unclassified Information Program is set up by NARA, and it was set up by executive order under Obama. That is the only agency that is designed and set forth to control and monitor the CUI markings. Their goal was to standardize the more than 100 different markings currently used by agencies. It was to develop the publicly available CUI Registry, which we will take a look at a little bit later. It was to standardize the markings for CUIs and mandate their use when disseminated outside the government, and to identify and establish the decontrol and authority and processes. So this is the 23 different items that are covered under the CUI Registry. We're going to be concentrating today primarily on export control. And in export control, it should be noted that there's actually kind of two aspects of it. One aspect when we talk about CUI is the stuff that is specific to export control and the export control process and stuff. And the other piece of it is that export control is one of the ways that they do actually control controlled unclassified information, or CUI. In the registry, you have links to each category and subcategory, and these links include the description of the materials the item controlled, what's the requirement for the control, and what's the citation. And it's a very, very user-friendly registry. You can go into a particular area and click down through, and it provides all of that information. There's other reference information provided also that are executive orders, the NIST publications and FIPS standards, as well as any computer-based training materials that are applicable. So, under export control, that subcategory listing describes what is covered by export control. And what it is unclassified information concerning certain items, commodities, technology, software, or other information whose export could reasonably be expected to adversely affect the United States national security and non-proliferation objectives. And by non-proliferation, what we are meaning by this is having our weapons and so forth being given to our adversaries, and in many cases even our allies, in a way that it's not protected. It can also include dual use items, any items that is identified in the Export Administration Regulations, the ITAR, the International Traffic in Arms Regulations, the munitions list, any license applications, and any sensitive nuclear technology information. There's a second category, which we really aren't going to discuss, which is export controlled research. Under controlled unclassified information, there's two categories. There's CUI Basic and there's CUI Specified. And the difference is if you have something that is CUI Specified, there is a specific law or regulation that is going to control how that is to be protected and how that is actually going to be potentially released. Under CUI Basic, it's simply a government-wide policy that requires the control. And whether these two categories are applicable is actually identified in the registry. One of the confusing factors is that there's such broad definitions of what could be considered CUI. And where they've done it under the basic is you have something that is, the impact has to be at least moderate. If it is less than moderate, it is by definition not CUI. As far as controls are concerned, it can be both a minimum or a maximum control, or there's even a middle ground of control as well. Agencies may not control CUI basic information at a level higher than moderate if they're disseminated outside the agency, unless it's by formal agreement. If you're a contractor, you're subject to NIST ASP 800-171 if you are dealing with any CUI. If it's CUI specified, the NARA CUI listing doesn't specify the controls required. Instead, it tells you what regulation you have to go to in order to see how that's to be controlled. So here is an example of drilling down into the export control. And this is kind of hard to read. So what I've done is I've actually pulled it out and covered it on this slide here. So what you have is you have the regulation, and this is just an excerpt, by the way, that you have the actual regulation that describes how it's to be safeguarded and or disseminated. You have a designation of whether it's basic or specified. And then you have a designation of what the marking is. If it's basic, it's just simply marked with CUI. If it's specified, it has to be marked with CUI/SP-EXP, exactly in this manner. If there are specific sanctions for violating the safeguarding, then they're listed in this last column right here. And the one particular one I picked up was 42 USC 2168B and C. The difference between B and C is B relates to civil penalties up to $100,000 per violation. And by the way, that's per violation. And C deals with criminal potential violations, and that's something that the agency that puts out the authority can designate what those criminal violations can result in. Export controls. So what is an export? Most people never get past the actual shipment of goods, but in fact, it's a lot more than that. It can be looking at something that is export controlled by a foreign person, downloading software in a foreign country. By the way, that means also if you're uploading software to the internet in which it can be downloaded in another country, you have exported, whether someone has downloaded it or not. And these are some other ones. We talk about the internet, phone calls, having someone, a foreign person, look at something on a US server, or for that matter, storing them information on a foreign server. And this is a lot of this access by foreigners is a lot of what Bill is going to talk about in the next section. You have something called deemed exports, and that's where you don't actually have something move outside the US boundaries. What happens is that foreign national is in the United States and the technology is given to them or shown to them. This happens a lot in the university environment, so you have to be very, very careful if you're dealing with universities. A re-export or deem re-export has a very similar effect. Is you start in one country and it moves to another country. If something is sent by end-to-end encryption, with some exceptions, to a US person in a foreign country, that's not an export. Some other key definitions. Who is a US person? It's someone who meets any one of these. The two most common are someone who actually has a US citizenship or someone who's given a permanent residence, i.e. what used to be called green card holders. But there are also still asylums and refugees, corporations, and any part of the United States government. A foreign person is very easily defined. If you're not a US person, you're a foreign person. Some examples: someone who's in the US on a temporary visa, a foreign corporation that is not incorporated or organized to do business in the United States, an international organization or foreign government, including an embassy to another country. You have to keep in mind also that if you have a corporation that is incorporated in the United States, but it is 100% owned by a non-US company or person, then you might have some other special considerations that you have to be careful for. And a lot of, for example, BAE System is owned by a UK company, so they have to do special activities when they're doing they're sending stuff around through the company to make sure if something is being sent within the United States, it stays within the United States and it does not go also to the UK. Exports are controlled by 3 laws. We're going to mostly concentrate on the International Traffic in Arms Regulation. And when we talk about controlling data from here forth, we really are talking about controlling technical data. And if we're talking about technical data and we're talking about controlling technical data, it is going to be covered by one of these 3 laws. However, in some cases, even if it's especially under the Export Administration Regulations, the control may be nothing more than it has to be listed on a manifest. And nothing else is there. If something is controlled under ITAR, though, you do have to have a license. So what is the ITAR? It is found at 22 CFR, parts 120 to 130. It's administered by DDTC at the US Department of State. It's a very complicated and burdensome regulatory compliance regime. The regulations are broad in scope and application, and they apply outside the United States as well. So what are the basic requirements? And by the way, the term basic here does not have anything to do with the term basic we used earlier. And it deals with exports, re-exports, and temporary exports of the following things: hardware, information technology, software, technical assistance, any registration requirements, brokering, denial policies, and then any requirements regarding certain payments. Licensing. If it's something that's ITAR, you are going to be required to have a license. It is very simple. There are different licenses depending upon what you need to do. There's some very, very limited exceptions, such as Canada. The UK has also had a limited exception, so to speak. If something is licensed for export, it cannot be resold, transshipped, or re-exported without a DTC approval. Manufacturing license agreements and technical assistance agreements also have some very special provisions. One of the biggest complaints about ITAR licensing is that there appears to be a lot of table rules, and I put that term in quotation marks, that the actual approvers of the licenses follow. They're not consistent across all approvers. And so sometimes license requests are sent to one approver who says do A, B, and C, and when you do that to the next approver, they deny it because you didn't do C, D, and E. Also, in a lot of cases, the licenses are sent to whatever program office is controlling that particular technical data, and so that can add a considerable time, especially if they don't have the information that they wanted to see. So as you can tell, it's a very cumbersome process. So what is a defense article? The DDC has broad discretion to determine what fits within the categories, and they can also change what fits in there. If you have an article or service that is covered by an export, then that is generally covered by the EAR. But if it's on the USML, it's not going to be controlled by the EAR, which is the Commerce Department export licensing process. Keep in mind, something might be on the US munitions list, and it can be considered ITAR controlled, even if it's not on the list, if it had been specifically designed, developed, configured, adapted, or modified for a military application, and this is a big important point, one, it does not have a predominant civil application, i.e. the civilian population is not using it. If the form, fit, and function performance equivalent is not the same as the civilian application, or if it has significant military intelligence capability such that control of the ITAR is necessary. So a very good example of this is something that everyone deals with every day. Your computers, for the most part, unless you're an Apple user, and I'm assuming since you're listening to this, you're probably not an Apple user, but the Microsoft Windows product for the longest time was not allowed to be sold the latest version due to the cyber security in the latest version without specific ITAR licenses. Today, that is no longer true under the dual use, but for a very long time, that was a very true thing. And a lot of people got tripped up when they took their laptops overseas with the latest version of Microsoft Office, but Microsoft, the operating system, they effectively had an export at that point in time. Technical data under the ITAR, it's in any form. It does not include general scientific, mathematical, or engineering principles, any public domain information, any basic marketing information, but be very careful under that one because we do mean basic. If it includes any kind of technical information, then you might have to get a license in order to have it be included, because it is included under the ITAR, and you need to construe it narrowly. If in doubt, it is strongly recommended that you get it checked either with legal counsel, or even you can check directly with the State Department. They will address and look at certain product categories of information and or technical data to see if they believe it should be covered under ITAR. Defense services, the big thing here is people don't think about training, but that can, if it's training on something that is covered otherwise under the ITAR, it would be also included here. And we talk about military training especially. Data sovereignty. So data sovereignty is a term of art that we're using today to describe the nationality of data. So if you think of something as being classified as CUI, then the data sovereignty of that data needs to be the United States. Three aspects to consider is where is the data physically located, who has access to the data, and unintended spillage, which is anything that causes properly protected data to be exported. And we've talked about a number of examples where unintended spillage has occurred or can occur. All export control data that requires at least moderate protection is considered CUI. And all the requirements of CUI is going to apply in addition to any export control requirements. If the export control data is less than moderate protection required, it is not considered CUI. It may still be export controlled, but it is not CUI. If you have data that is data related to the Department of Defense, cybersecurity, or Homeland Security, generally that data is governed by the ITAR. So applying these three aspects for data residency, data should be stored on computer services physically located in the United States. I actually live in Ashburn, Virginia, which is becoming we've replaced the farms that have cows and horses around here with computer farms. Data access, only US persons may have access to the data, and they must be physically located in the United States. And then we have the unintended spillage, and all of these we've described already. You have a US person, a non-US person having access to the data in the United States, a US person who is not physically located on a US military base or embassy has access to the data outside the United States. A non-US person outside the United States has access to the data resident in the United States, and Bill's going to talk about one of the big areas where that is has the potential of happening. or a US person takes the data outside the US on an information system. All of those above scenarios presume that there is not a valid export license for the data. One of the other big problems that happens is you have someone in the United States sends an email to someone who is a US person, and they're not aware that that person is no longer sitting physically in the United States. That is an unintended spillage. That concludes my portion of this presentation, and I'm now going to turn it over to Bill Wootton, who will do the next portion of this.
Thank you, Jody. As everyone can see, there's a lot of complexity when trying to work with export control data and the various types of data that's involved and various classifications around it. But from an IT professional's perspective, the real challenge really comes with how do we protect this data? How do we make sure that from a technology perspective, we're meeting our compliance requirements? So we're going to start with just kind of going back and comparing the CUI impacts with CMMC, as well as with data sovereignty and what the additional requirements are. So for everyone today who's worrying about clause 7019 and trying to meet the self-assessment rules, that's typically focused around NIST 800-171, where we all have the 110 controls, the SSP, the POAM, and we're all trying to kind of answer the mail on that today right now. As we all transition towards CMMC, that takes us from the NIST standard into the CMMC standard. That adds those 20 additional controls, and probably more importantly for a lot of folks, adds in that process piece, the maturity piece of everything. And now we've gone from a place where we're trying to put a score in to where we have a pass-fail type of threshold to meet CMMC. All of those rules are being discussed pretty extensively today throughout the industry, but the important part is, even within the bounds of CMMC, the idea of data sovereignty is above and beyond what CMMC requires. And that's an important factor as we look at various technologies, various controls we put in place, how we're controlling the flow of that CUI data, in this case, export controlled CUI data, throughout our systems and our organization. So to reinforce the data sovereignty piece, we have data residency, data access, and unintended spillage is what we're trying to prevent. And we'll talk about each one of those in detail. To start with data residency, all data must be stored on computer systems, computer servers, and equipment located in the US. So from an example standpoint, if we have an organization that holds ITAR data and they're predominantly on-premise with their environment, that data will sit in an email server, a file server, maybe the desktops, and that data will sit in the company or location. In this case, it happens to be in New York, and everything is residing in the US. So that's a nice, easy, clean example in terms of how to ensure you have data residency. Now, in today's world, of course, we also have to worry about folks with laptops and mobile phones and whether or not they have any data on those devices when they travel. Someone maybe takes a weekend in Cancun. Are they taking that laptop with them, and what data is crossing national boundaries with them when they do travel? Today's world, of course, we know most folks are moving into the cloud, and that presents different challenges with respect to making sure we're controlling the flow of export controlled data. In this example, we have some data. It's sitting in a cloud repository. It might be an email server or a cloud-based file server, and that server sits within the organization of the cloud provider, which seems pretty straightforward, except in today's world, most cloud providers happen to be global organizations. So unless that cloud provider is absolutely maintaining that their data is all held within the US, you should assume their data is also being transmitted or replicated somewhere else worldwide. And that vendor is really not a vendor you should be working with when it comes to export controlled data. Now, there are some solutions out there that promote encrypting data, and that gives you a little more flexibility if you happen to have a file that sits overseas, but if it's encrypted, you have a little more flexibility with that. But as an IT professional, you can see how even with that file being encrypted, you now have the problem of not just one file, but all of your files, and making sure you find and encrypt every single ITAR data while either not encrypting the files that are not export controlled, or you run the risk of missing those individual files, and therefore you have a unintended spillage. The other option on that with those types of systems is to encrypt everything, but that tends to lock down the entire environment. And these tools also break other common features like search and e-discovery, and really tie the hands of the IT professional from doing the rest of their jobs in a lot of different ways. From a cloud-based standpoint, what we try to look for all the time is US-based services. There's a Microsoft 365, the commercial version is a good example of this, and we'll talk about why it's good and what some of the challenges are with the commercial version a little later on. But in this case, Microsoft will attest, and they will put in writing that all of their services for the commercial version, if you have a US tenant, your data will stay in the US. And that's what we look for when we're working on export control data. But it's as Jody mentioned earlier, it's a little bit more than that. In addition to data residency, we also need to be concerned about data access. With data access, only US persons may have access to the data, and they must also physically be located in the US. So what's this really mean? So in our original example, when we talk about data access, and we've got cloud-based services that are US-based, okay, we also have to ensure the support team is based in the US as well. We also have to ensure the monitoring and the management and all of the anyone who's touching those systems from an administrative standpoint are also based in the US. So, and this is kind of what takes us into the idea of unintended spillage. Now, as Jody talked about a minute ago, unintended spillage happens when we have a non-US person that has access to data that's located in the US, when a US person who is not a resident on a military base or embassy accesses data outside of the US, or when a US person takes data outside of the US on an information system, back to our trip to Cancun, and then possibly when a non-US person outside of the US has access to the data that's resident in the US. And we're going to focus on that over the next couple of slides. So back to our example with a cloud-based service, US-based data residency. We're comfortable, we've got all the files sitting in the US, but what we need to be sure of is that that support model is not a follow the sun model. And this is one of the challenges with the Microsoft 365 commercial product. Their support services happen to follow a follow the sun model. We also need to be sure that the network management and monitoring and administration is not based overseas. We know a couple of providers that are fairly prominent in the MSP industry. They have US-based support, US-based residency, but their network operations center happens to sit in India. That creates a situation where those engineers have the opportunity, they have the potential to access that data, and even if they don't, that is considered unintended spillage. So as an IT professional, we need to think about what are we going to ask for when we talk to vendors and we evaluate what services and solutions are we going to use, both to operate our network and especially to secure and meet compliance requirements. We typically recommend folks to ask about data residency. Make sure that vendor is going to maintain that their data stays in the US. Also, talk about, ask a little bit more than just that simple question. Find out where do they support their data, where is their administration, their engineering and design, where is their corporate sit? Are they really committed to meeting these controls? We were talking to one vendor that was selling security services, and they checked almost all of those boxes. Their coders happened to be in India, and everything was fine because it was a sandboxed environment, and they don't touch the production environment. Everything's great, except as we started digging a little bit, we found out that their coders use a complete copy of their production data for their testing data. So they were actually taking their full production database, copying it, putting it in their coding environment, and then putting it in a place where there was absolutely no control over it. Needless to say, we're not using that vendor. So this goes to or towards one of the things that we really strive for folks to look for. What is that commitment to the defense industry? Are they committed fully into embracing what they need to do to meet these requirements? Do they have a government version of their services? Microsoft, for example, has a government version of their services. Salesforce and a lot of other companies are all creating separate versions of their solution to dedicate themselves to the government and in a lot of cases, the DoD and the defense industry. Finally, are they willing to attest to both CUI and ITAR data? And in a lot of cases, when we have conversations, the tone of the answer will tell you what's happening. If it's kind of a brush off, like I'm sure we do this, I'm sure it's fine, we have federal customers, it's got to be good, don't take that for an answer. You need a firm, confident answer that has some data backed up as to why they can meet these controls. This will bring us back over to Microsoft 365 and why that is a great example for this whole topic that we're talking about. When Microsoft first launched Office 365 to tremendous success, it was just unprecedented how it really shepherded the move to the cloud for the entire world in a lot of ways. And with that global success, Office 365 sits and lives in the commercial version of Azure. This is a global infrastructure that carries the Azure dependencies that are also a global infrastructure, and it also has that follow the sun support and administrative model. Now, as Office 365 grew and got more and more popular, Microsoft started selling it to the United States government. And as a result, they realized they had some additional requirements, things like CGIS and IRS 1075 that they needed to work on. And so they actually built what's called a data enclave called the Government Community Cloud, or GCC version of Office 365. This is a completely separate and isolated version of Office 365, but it also lives in Azure Commercial. And therefore, from an administrative standpoint, from a service standpoint, it still has a follow the sun model. So as Microsoft started selling more and more to the federal government and they started to pursue DoD-based business, then they realized that wasn't going to work for these requirements. That's how Azure Government came to be, where Azure Government is a completely separate air-gapped version, completely separate data center version of Azure that is completely designed to support the defense industry. It includes not only data residency, but US support and administration. So as Microsoft started selling Office 365 to the DoD, that's how that sort of came about. If you are Navy.mil, Army.mil, that's where you are going to live in the Office 365 version of the DoD version of it. Now, obviously, as they started having success in this space, they started to realize that the defense industry is more than just the DoD. It includes the defense industrial base, and they needed to have a version of Office 365 that was built for defense industry customers that could meet all of the requirements, including export control data. And that's how we wound up with GCC High, the only version that is available for commercial purpose that Microsoft will attest to meeting export control or ITAR requirements. So just kind of finalizing this on one last chart, you can kind of see the differences between the commercial version, the GCC, and the GCC High version in terms of various types of compliance. And a couple of things that'll pop out here, all of them are now FedRAMP High, which is great news for the industry. And Microsoft just recently announced that they will meet, or I should say they will attest to DFAR 7012 clause in GCC. And what this means is in the infamous clauses C through G, they've now solved the technical challenges to be able to meet that, so they feel comfortable that they can attest to DFAR 7012. This has a direct relevance to those that are pursuing level 1 and level 2 in CMMC, because now they can attest to not only the CMMC level, but meeting DFAR 7012 as well. However, from a Microsoft perspective, their recommendation is that if you have a level 3 requirement or higher, that you should be in the GCC High environment. Microsoft's perspective is they have no way of knowing what flavor your CUI is. It may or may not include export control data, but if it does, it absolutely needs to be in GCC High. If you have any doubt, your most risk-averse choice is to go into GCC High. We talk with vendors all the time. We always ask them about whether or not they hold export control data. And I can tell you there's more than a few that have absolutely insisted they don't. And we can tell by the type of business they're in, they probably do. So there's, unless, if you, Microsoft's recommendation is still going to be GCC High for level 3 and higher. So that concludes my portion of it. I want to kind of transition over and start looking at questions and see how we see if we have any on the board there, and we can start addressing them.
Hey, everybody. Thanks so much, Bill and Jody. We did have a few questions during the presentation, so we'll be able to, I think, get to all of them. First question that came through was about a recent Microsoft announcement with respect to GCC. Bill, I think that's probably something for you, perhaps?
Yeah, thanks. About a week ago, Microsoft came out with some updated guidance around the ability, and I referenced that at the end of the conversation, that GCP version is now, for lack of a better word, meets the requirements of DFAR 7012, as well as CMMC, and I probably should update the guidance a little bit in the way I spoke about that. They're actually stating levels 1, 2, and can meet level 3 requirements in GCP. However, there is a note in that blog, and Microsoft is very firm in the fact that if you hold any CUI specified data, meaning things like ITAR, nuclear, or anything else that has no foreign requirements, you still need to go to GCC High. GCC does not meet the requirements of anything that is export controlled.
Great, thanks so much. Jody, I think this one probably is for you. What is meant by moderate confidentiality impact?
So basically, when we're talking about the moderate, is if you look at the impact, if a particular item of data is released, and whether or not it has a big impact on the government or on the releaser. So say, for example, and this is a personal example that many of us have been dealing with, is the issue, say, for example, your home address. If your home address is released on a website or from a bank or something like that, it probably doesn't have a huge impact, because ultimately home addresses, people give out home addresses or your work address pretty much readily. It's not something you try and protect up there. Contrast that with your social security number, which for that you're going to want somebody to be protecting it at a high level, because it's going to have a high impact if that information is released. Somewhere in the middle there is something that's called moderate. And for some people, it might be their phone number. For some people, it might be other personal information. So when we talk about CUI and either basic, moderate, or high impact, it's the impact that the release of that data might have if it is released. And so if it's basic and it doesn't have a big impact, then in that sense, it is not going to be considered CUI. Everything above that is going to be considered CUI.
Okay, great, thanks. We have another question, and this is for both presenters. How do we deal with a DoD contractor like Tata, who we know is based in India, but claims they are domiciled in the US? I don't want to risk our ability to execute a contract because we are using them as a sub. Do we exclude them from bid, or is DoD going to address this?
So, Jody, you want to take lead, or you want me to take first crack at it?
Go ahead.
All right. So there's a lot of different aspects to this from the business standpoint that I probably don't have a solid answer for. But the first thing is, how does Tata represent themselves as being domiciled in the U.S.? Most foreign organizations that want to work with the DoD will set up a U.S.-based subsidiary and do certain things to segregate that business from the home company in India. There's a whole set of rules and process in that area that they set up these different barriers, and so that's kind of solves that part of the problem. Even if for some reason that were not the case, then I'd probably defer to Jody to talk a little bit about what's the type of data in the contract, and are you what's the data from that contract are you actually sharing with the vendor? Just because you have a contract and they're on a teaming partner doesn't mean you're giving them full access to everything that you do in that contract. They may only be for a small portion of it that you can provide, the non-export control data related to that contract. In terms of how that bid works and all that other process goes, that's probably outside of my my expertise.
So I find it very interesting. I'm gonna address your last piece of it first. On the DoD going to address this. DoD isn't going to address unless they have the particular vendor is a vendor that is in the RFP that you have to use. DoD does not address those kinds of questions, quite frankly, ever. They view that every company, you decide who you're going to partner with and how you're going to part with them, and they're not going to address it. The other interesting thing is the use of the term domicile. It's not a term that is used when we talk about whether or not ITAR data is considered or whether CUI data can be released like this. What we talk about is in the terms of whether or not the company is a U.S. person. And to become a U.S. person, they have to be organized under the laws of the United States of America. There are no exceptions to that for companies. So when we look at that, it's not a question of domicile, it's a question of, is the actual company that you're dealing with organized under the laws of the U.S. government, whatever state it might be. And by the way, and if somebody says, oh, we're a U.S. company and we're organized under the laws of the United States, the next question would be, is it's under what state? Because the federal government, with the exception of some of these companies that are quasi-government companies, does not set up companies. States do. So that's another aspect of it too. They can be owned by 100% by an Indian company. And then the question becomes, if they're a U.S. company, now we say that, so they're a U.S. person, is, much like Bill said, there is going to be some requirements potentially that have to go into play here with regard to whether or not what data they may or may not be allowed to see. And there's no way that I can answer that question. And this comes back into the level of that might be legal advice you need to go and get. And you need to look at that. So my bottom advice is if you have a specific situation like that, is that you do actually seek legal counsel. And you also get the information from the company Tata to find out where they actually are organized. One of the things I always recommend, and people look at me kind of strange, is when you have a teaming agreement with a potential subcontractor like that, I want to know what state they're organized in. And part of that is because it does give me a trigger point to say, okay, is this a U.S. company or not a U.S. company, especially when they're a subsidiary of another larger company. I hope that answers your question.
Great, thanks, Jody and Bill. We have I think a quick question, just some clarification, and it is if some ITAR data is CUI, what's the guidance to determine that?
So I think that answer is easy. All ITAR data is considered CUI. You may have CUI data that is not ITAR, but all ITAR data will be considered CUI.
That is correct.
Great, thank you. Next question about small businesses. Small businesses are disproportionately impacted by the costs of CMMC compliance at level 3. I've spoken with several organizations that claim to be able to help my business become compliant, but I don't have the expertise to evaluate their solutions. Can you say a few words about the landscape available to third-party IT services to help us, small businesses, attain compliance?
Wow, could probably do an hour on that by itself.
They do.
Yeah, it's a real challenge in the industry today. It's a challenge across the entire vendor landscape for that. We certainly deal with small companies every day that are going through a significant amount of sticker shock for a couple of different reasons. In some cases, it's because they've underinvested in IT and they've underinvested in cyber, so their baseline is much lower than maybe what their budget should probably be. In a lot of cases, it is that they have made decent investment, reasonable investments, but they haven't gone to the extent that they need to live in this new world where we have all of these, not just, you know, random people sending phishing emails out, but we have legitimate, sophisticated nation states that are going after our supply chain. And they're not just going after Lockheed Martin, they are going after everyone across the supply chain. And you know, these standards in a lot of ways are required to protect our nation's infrastructure. I do personally think, and this is entirely me personally, that we will see a little bit of an adjustment in the requirements on what it takes to get to level 3 as we start to see really what the full impact is and what the full cost structure is. Relative to IT providers like ourselves, like a lot of the folks out in the industry, we are making every effort possible to develop solutions that will help meet level 3, to take advantage of vendors that are committed to the industry, like our friends at Microsoft, at AvePoint, and other places. And we're working really hard to find ways to build that to scale to help lower that cost infrastructure for you. It's going to be a process. I don't know if there just is not an easy button at this point. There is going to be some investment. There's going to be a fair amount of cost associated with it. I'd go back to some of the things I said earlier on about what you look for in an IT provider. I mean, in a vendor, that applies to an IT vendor as well in terms of their commitment to the industry and how they're tailoring their solutions to the defense industrial base.
And let me add on to that a little bit. One of the interesting things, so I do listen to a lot of the town halls that CMMC-8, the board puts on. And one of the comments that was made last week, and I thought this was something I was very pleased to hear, is that when an RFP comes out, it is not supposed to necessarily say the entire RFP is at a particular level, or say a level 3 level or level 2, or, well, level 2, everybody pretty much is agreeing. Level 2 isn't going to really happen. That's just going to be an interim level between 1 and 3. So you very well could be on a proposal or a team member where you're just at level 1 and that's all you have to be at. When we start talking about the small business costs, for those companies who have been working in DoD for some time and who have more likely than not been handling CUI for some time, you should already be compliant with the 171-800, yeah. So that should not be a jump. So then the big thing is going to be, it's going to be the cost of actually getting the certification. And one of the other things that there's out there, there is going to be, I mean, it's going to be part of your overhead. It's going to be an overhead cost, much like you have to get your accountants coming in there and doing your audits and so forth like this. So while there is certainly a cost associated with this, this should not be the huge cost that I think some small businesses are looking at. I will also recommend highly the local PTAPs, which is a small business organization in almost every state and a lot of localities have. I know in Virginia here, George Mason does it. And I don't ask them what PTAP stands for. It's PTAP, but if you Google that, it's there. But for example, my understanding is through PTAP, there is money being provided to small businesses to help them become cyber compliant. Another thing that I've heard be used, and this is directly up Bill's alley here, but if you have most of your business going up in the cloud and your cloud provider is compliant, then the only thing you're really looking at from a compliance standpoint at that point is the laptops that people are taking or their desktops. And that was one of the other things that came out about at this latest town hall meeting, was the fact that the intent is if you have another organization that you're relying on for your information technology and they are compliant, you get to then just do the incremental piece to see your compliance. And so I think this was another way that really, really can help the small businesses.
So I'll add on to that. Jody's absolutely right. Most businesses that, especially those that are not in manufacturing, are putting as much as possible into the cloud. There's a lot of value in that. We use Microsoft 365 for a reason, because that is becoming the go-to. That's one of our primary products, to be full disclosure on that end of it. But it does give you a single platform to do the majority of things that are on there. There's certainly some cost associated with that. And there is some work to do that. While that gives you the platform to do it, there's a lot of work to be done to set the configurations, to make sure that you have everything activated and configured properly, as well as the overlay of policies and procedures and the appropriate monitoring and maturity that goes with all of that. Relative to the grants, Gen Edge in Virginia has funding available for Virginia companies that are pursuing cyber. I know Maryland has a great organization. It's escaping me off the top of my head, that also makes some funding available. And there are other PTECs out there that are starting to get grants available through the DoD, funneled through the SBA, that are helping with some of this work. And certainly check with whatever state that you're in or headquartered in, to check with their local PTEC and see what they're doing.
Great, thanks both of you. Thanks both you guys. We do have a few minutes left. A couple more questions. Jill asks, there are CUI marking requirements when the item is printed. Does all ITAR information need CUI marking requirements? It seems like the ITAR marking requirements are different from CUI marking requirements.
So ITAR is a subset of CUI. One of the things that came out with CUI was to try and go with a uniform marking requirement. I teach for federal pubs, and I can tell you, as late as my last live class that I taught to the government, which would have been a year and a half ago, when I mentioned CUI and the fact that it was a uniform marking requirement for that at DoD organizations, and I was teaching a course on information technology and data markings, many of them were not aware of it. So even though the law was changed, I want to say it came into law in 2016, it has been a very, very slow process to get the markings done correctly. Ultimately, the markings should be all uniform. So if something is CUI and it is ITAR controlled, it is supposed to have a uniform set of marking that will show across this. I will also be honest with you, if you do all the markings that the NARA came up with, you basically, that's page 1 of your document, and then page 2 will be your title page. I mean, it is very, very extensive. But the idea was to get away from one organization saying CUI, one organization saying FOUO, one organization saying agency private, one organization has something. In fact, if memory serves me, there was something in excess of over 1,000 different markings that in the end meant the exact same thing, which was that it was controlled unclassified information. So while yes, you are still seeing some differences in the markings, ultimately all the markings should be the same.
Great, thanks Jody. And I think there's a quick follow-up to that from Christopher. How do you mark non-standard file types such as CAD models?
Okay. Well, basically it's my understanding, and I am not a software person. Let's start with this. I'm not a software person, but I've been advising software people for a very long time. And my understanding is that there is a way to go into any software file, and it might show up in the remarks section. It might show up in the information section. It certainly can show up when you do a printout of a CAD file. Obviously not when you do the 3D printing, but when you do a printout of a CAD file as a footer or a header or something like that. And you do then, you basically make the marking. I happen to know this for a fact that even little circuit cards can get marked with markings, because there's a court case that they managed to etch the name of the company that made the card, but they didn't manage to etch that the card was supposed to be protected. And the court case said, if you can etch that on, and by the way, you need a microscope in order to read it, but as long as it's etched on there someplace, that's what you have to do. So just because you are using a CAD file or any other kind of file, it should not change your ability to do the markings.
Yeah, and there are capabilities and features out there to apply data labeling on various types of file types. Used to be called Azure Information Protection. I think it's now called Microsoft Information Protection. Does exactly that. It will either in a manual way and in some situations an automated way put a data label on a file or on a document. That particular service works great with Office files as well as PDFs. I don't know if it applies to CAD files or not. There may be a couple of other tools out there that also do data labeling that might be a good fit for CAD files. I'll check and see what the current process is for and how folks address CAD files, and I'll follow up directly with you.
Great. Thanks.
Can I come back to a prior question real quick and just let you know that PTAC does stand for Procurement Technical Assistance Center, and thank you, Joyce, for pointing that out. And there's also a website. Joyce also pointed that out, which we will we'll just go ahead and add that maybe somewhere, the website for the PTAC. But again, if you Google it, it's very easy to find.
Yeah, we'll be sure to add that onto the presentation before we send it out. Bill, did you have anything?
Just, go ahead, keep going. I think we're good.
Okay, great. So one follow-up to this marking question from Diane. She said, so are you saying that it's not necessary to use the marking requirements from NARA? Where can we find guidance and information on the uniform marking requirement for CUI? Okay,
I am not saying that it is not necessary to use the markings from NARA, okay? What I am saying is that it has not been rolled out quite to the level that it should. Always, always, always contact your contracting organization to find out how they're how they want their documents marked. And while I'm going to throw that out there, I'm just going to say there's a recent Boeing case which basically is saying if you have intellectual property that you consider to be proprietary to your company, based on this Boeing case, you should be marking that in addition. Now, I know that that has not gone out to the different contracting organizations, but I think that if you don't mark it, and there's a lot of commentators out there just saying that now with this Boeing case out there, that if you don't mark, you're taking a risk that the government is going to be able to hand it. Well, the government already can, because if they have unlimited rights, but that other people who work for the government can also use it. So that's one of the things that has definitely been changing. But you need to talk to your contracting organization. This is a process, not a final solution at this point.
And Jody, if I remember right, I think of the DoD 5000 regulation that's being written is a big chunk of that, or at least a portion of that, was to address the shortcomings on the government side with marking data.
That is just one piece of it, yes.
Great. Okay, well, gosh, we couldn't have planned that better if we'd tried. It's 3 o'clock on the nose, and we seem to be at the end of our questions from the audience. So we'll wrap up. Thank you both, Jody and Bill, for your time today, and thank you to everybody who joined us. We had a big group, and we certainly appreciate you tuning in. As I've noted before, we'll send out the presentation to all of the attendees afterwards. We'll have it posted online. And you can reach out to both Jody and Bill. They have their contact information on the last slide. For C3 in particular, you can learn more about this issue and others related to CMMC by going to our website, c3isit.com. And you can also follow us on Twitter and LinkedIn and Facebook and all of those great places as well, and get our monthly newsletter. So thanks, Jody and Bill, and thanks to everyone. Have a great rest of your afternoon.
And I'm going to do a little bit of a plug. We do blog posts on our webpage. It's McMahon, Welch, and Learned. Gosh, I don't even know what the exact webpage. Should probably have put it in here. But we do blog posts on subjects and items that are of concern and interest to small and mostly medium-sized businesses who we represent, not the least of which is dealing with cybersecurity, which I deal with, intellectual property, in those areas that I more deal with quite a bit.
And I'll put one more plug in for Jody in particular. She has a series of articles that she's posted on her LinkedIn page. You can find her on LinkedIn looking at Joanna Jody in quotation marks Reed. And those are some really good posts that she's written as well.
And those are also on our blog.
Great.
Thank you.
Okay. Bye, everyone. Thanks.
Thanks, everyone.
Bye.